Thank you all for being here. We are really excited and anxious to down with you guys and talk about this finally. We've kind of pulled our team of SMPDC planners together and also invited Phil Saucier here to provide some legal counsel. So my name is Reagan Young. I'm the Director of Communications and Member Services at SMPDC. We're also joined by Jamel Torres, our Director of Planning, and Michaela Jordan is our Senior Planner. We're going to get started with the actual presentation, and I wanted to let you guys know that we're going to hold Q&A till the end because I know that's kind of the whole point we're doing this, right, is so that you guys can ask your questions. So a quick overview of what we're going to go through. I'm going to talk about the timeline of all of the different effective dates of these new laws. And then I'm going to pass it off to the planners to talk through 5 of the most recent laws that were passed in the 132nd legislature, their first session. So this happened earlier this year. And we will talk about the actual names of each of these bills, but you'll notice we've used some familiar names to kind of make that easier for us as we go through. So we'll be referring to them by these names. And then we're also going to share a little bit about the state rulemaking process, what SMPDC has in terms of resources, and then we'll open it up for Q&A. So first things first, as all of these different laws come into effect, there are some major dates along the timeline we want you guys to be aware of. So out of the 5 laws that we're talking about, 3 of which have either in part or in whole already come into effect as of September 4th, 2025. So that includes a couple of pieces of LD1829, that omnibus bill that includes a lot of different specific changes, LD422, the parking law, and LD1655, the chickens law is what we're calling that. It's a bit cheeky. And then in the future, going forward, LD1184, the reporting bill, that one comes into effect January 31st, 2026. And then it is an annual requirement for municipalities that have residents over 4,000 every year thereafter. And then the other pieces are the rest of LD 1829. That chunk of that bill has 2 different deadlines depending on your type of government. So if you're a council form of government and you can adopt your ordinance changes at the council level, they've made that deadline a bit closer, July 1st, 2026. And then if you are a town meeting type of government and you need to go through that full town meeting process to adopt ordinance changes, they've pushed that deadline out to July 1st, 2027. That date also applies to LD 997, the residential and commercial. I'm going to pass it off to Michaela to get us started on the big 1829 omnibus bill.
Thanks, Reagan. So this is formally an act to build housing for Maine families and attract workers to Maine businesses by amending the laws governing housing density. I'm sure this is the law that most folks are familiar with or have heard a little bit about. It has a lot of different changes in it. It preempts local zoning that restricts residential density, and it is designed to increase housing supply statewide. As Reagan mentioned, there are a few different implementation dates for this bill, so make sure you're noting that as you're looking at your ordinances and what you need to amend. The rulemaking is drafted for the omnibus bill, and it is open for public comment currently. The biggest areas of change in this bill include dimensional standards in growth areas, as well as in areas of public water and sewer service. And for those who aren't familiar, dimensional standards include things like density, lot size, setbacks, and road frontage. This bill also changes the definition of a subdivision. It changes thresholds for planning board review of residential projects. And it also changes provisions with regard to accessory dwelling units. Next. So for each of the bills, we have a table that has the topic on the left, the state requirement in the middle, and some steps to abide by that state requirement on the right. We'll go through these in some detail. So the first topic for the omnibus bill is the minimum number of units per lot. So this is a follow-up from LD 2003 that was passed a few years ago. So in 1829, it says that all areas that allow residential uses must allow 3 units. And if it's a growth area or served by public water and sewer, must allow 4 units. So steps to comply with this requirement include amending your zoning ordinance. For example, amending districts A, B, and C that are outside your growth areas and that don't have public water or sewer, but that do allow residential uses. You need to make sure those allow at least 3 units per lot. And then say you have X, Y, and Z districts that are in a growth area or served by public water and sewer, you need to make sure that those allow at least 4 units per lot. The omnibus bill then lays out different minimum lot size requirements for different types of areas. So that is the next 3 rows of this table. So for minimum lot size in growth areas with public water and sewer, you cannot require more than 5,000 square feet for your first 4 units. And then you cannot require more than 5,000 square feet per unit for each additional unit. For minimum lot size, not in a growth area, but with public water and sewer, you can't require more than 5,000 square feet for the first 2 units. And then again, not more than 5,000 square feet for each additional unit. For your minimum lot size in growth areas, but with no public water and sewer, it can't be more than the Title 12 septic minimum, which is typically around 20,000 square feet. So for all of these, you'll need to make sure you've identified your growth areas and identified your areas served by public water and sewer. You'll need to note where these overlap, and then you'll have to amend your zoning ordinances accordingly. Next, please. So this is a visual to help illustrate the lot size and density requirements I just went through. So this graphic is for growth areas with public water and sewer. Each color block represents a unique and different lot. So the blue block is a 5,000 square foot lot, the yellow block is a 10,000 square foot lot, and the green block is a 20,000 square foot lot. According to the omnibus bill, the minimum number of units that a municipality must allow is 5,000 square feet, is 4 units for the first 5,000 square feet. So that's 4 units on a 5,000 square foot lot. If you have a 10,000 square foot lot, you have to allow 4 units for those first 5,000 square feet, and then a minimum of 1 unit per 5,000 square foot additional to that. So on the 10,000 square foot lot, you've got the 4 and then 1 after. So a total of 5 would be the minimum requirement when you look at the math holistically. For a 20,000 square foot lot, it would then be a total of 7 units. And it continues on as your lot size changes. Next. So this is the same idea, but here we're looking at areas with public water and sewer, but not in a growth area. So the omnibus bill says that you must allow 2 units for the first 5,000 square feet, and then 1 after that. So in a 5,000 square foot lot, you have to allow at least 2 units. In a 10,000 square foot lot, you would have to allow at least 3 units, and in a 20,000 square foot lot, you would have to allow at least 5 units. You can allow higher density if you want to in any of these scenarios. You just cannot allow lower density. Next. Here we'll switch to some other provisions in the omnibus bill. As you might recall from LD 2003, it introduced affordable housing development requirements. 1829 adds to that. It says that you must allow 1 extra story, 14 feet, allowed above your zoning limit. So you'll need to make sure that you add in a height bonus for qualifying affordable housing developments in your land use ordinance. This will likely be in your special use standards. It could be in other places as well, but in most municipalities, it's probably in a special use standards section. When it comes to ADUs, there are a few changes. So you are no longer allowed to require owner occupancy in an ADU or in its primary dwelling. And you also must allow accessory dwelling units on multifamily lots as well. So if you have a provision in your ordinance currently that says ADUs are an accessory unit allowed on single family houses, that would no longer comply with the new state requirement because they must be allowed on multifamily as well. So for that, you'll need to amend your land use ordinance, again, likely in your special use standards. You'll also need to amend your definition of an ADU. As Reagan mentioned earlier, that's one of the provisions that went into effect in September. You also may need to amend your provisions within your ADU section of your special use standards. When it comes to sprinklers and ADUs, you cannot require sprinklers attached to buildings where the total unit count is 2 or less. So if you have one single dwelling unit and an accessory and the ADU is attached, you can no longer require the ADU to have sprinklers. For that, you should coordinate with your fire code and reflect in your permitting guidance. And in some communities, you might need to amend land use ordinances as well. Next. The omnibus bill amends the definition of a subdivision. It does keep all of the exceptions the same, but it changes the definition of a subdivision to the creation of 5+ dwelling units or 3+ lots in 5 years. So this means if you have, for example, 2 duplexes on 2 lots, that's no longer a subdivision. But if you create 4 single family units on 4 lots, that would still be a subdivision because you've surpassed the 3+ lot requirement. And the 3+ lot is the same as it was. It's just now that if there's smaller multifamily to 5 and dwelling units, but on fewer than 3 lots, then it's no longer considered a subdivision. Obviously for this one, you'll amend your subdivision ordinance, including your definition of a subdivision. You may need to amend an apartment conversion ordinance if that's applicable to your town. Some have them, some do not. So the next one is one to pay attention to. I know a lot of communities kind of use the opposite of this requirement as a strategy for implementing LD 2003. So you'll likely need to make amendments for this one as well. So this is around dimensional requirements for multifamily. Dimensional requirements for multifamily units cannot be greater than those for single units. So this means, say you require 100 feet of road frontage for a single family dwelling unit, you cannot require now 200 feet of road frontage for a duplex. Or if your rural zone is 2-acre minimum lot size, then it's 2-acre minimum lot for a single family dwelling unit or 2 acres for a triplex. You cannot require 6 acres for the triplex. It has to be still 2 acres. So amending the zoning ordinance and potentially the subdivision ordinance will be needed for that requirement. And some communities kind of put this opposite of this requirement in as a standalone measure in their land use ordinance. So just double check if you have that or not. The omnibus bill also changes the review threshold for residential units. So a municipality cannot require planning board review for 4 or fewer residential units within a structure. So a planning board still might see an application for a duplex or for a single family home, but it would be for a different reason, maybe for an environmental reason. But the planning board review cannot be triggered simply because of the residential units if it's 4 or fewer. So you'll have to amend the site plan review ordinance and likely your subdivision ordinance as well. Um, and then there is a provision on planning and appeals board training. This was one of the ones that went into effect in September. It says that all members must attend training within 180 days of this law or within 180 days of their appointment. So all current members should be looking to get this training to meet the 180-day deadline from September 24th. And then new members, as they join the board later this year and in following years, will need to make sure that they attend a training within 180 days of their appointment. And the steps for this are for your staff, whether that's a planning administrator, planning staff, CEO, whoever you work with your planning board, to track and ensure that new members attend trainings. And I think with that, I will be going to the next bill. Okay, so LD 1829 covered a lot, and I'm sure there'll be a lot of questions and Q&A about it. The next couple bills are much shorter. So this one, LD 997, calling it residential and commercial. It is an act to allow residential use development in commercial districts. This one has the furthest out deadline for all municipalities. It's not till July 1st, 2027. It preempts local control over restricting residential development in commercial zones, and it again is designed to increase housing supply statewide. The rulemaking for this one is also drafted and open to public comment. It's in the same rulemaking document as LE 1829, so you can look at and comment on both at the same time. Next. So on the topic of commercial zones, if you have a commercial zone in your community that only allows commercial uses, you'll have to amend that. So residential units have to be allowed in commercial structures. You'll have to amend your zoning ordinances so that way if you have, commercial zone X, commercial zone Y, commercial zone Z, that they allow residential. And you'll have to update your definition of commercial to align. There are then, the next 3 rows of this table are different provisions that the state specifically calls out that a municipality may institute if they want to. Not that you have to, but they are basically different limits or regulations to what residential units and commercial structures may or may not look like in a community. So the first one is residential unit limitations in commercial zones. And the bill says that you may limit the number of residential units in a commercial development. And doesn't specify how many. So that's something to note. You may also limit the ground floors of buildings. So you may require that any ground floor of buildings in your commercial zone are restricted for commercial use. So basically you're delegating your residential uses to upper stories or upper floors. If you think of, a classic New England downtown, that's kind of what happens naturally and has happened for decades, where the commercial uses are on the ground floor and there are apartments, townhomes, or condos above. And then it also addresses residential design. Some communities have design standards only for commercial buildings, so this is kind of acknowledging that. It's saying that municipalities may create residential design standards, but it does specify that those residential design standards cannot discourage development through unreasonable costs or delays. So it's basically just saying you need to have reasonable design standards and they can't, in effect, bar residential from being in the commercial zone because of how restrictive they are. So these are all, the bottom 3, they're all options. If your municipality has concerns about allowing residential uses in commercial structures, those are ways for you to add some regulations or qualifications to that requirement. And with that, I believe I will pass this on to Jamel to talk about parking.
Thanks, Michaela. So we're going to move on to LD 427. which is an act to regulate municipal parking space minimums. This was signed into law also in June of this year, and you must comply a month or so ago, September 24th, 2025. The law does preempt local control over parking minimums seen in ordinances in growth areas and is designed to lower costs and reduce barriers for residential developments statewide. And similar to the past few, rulemaking is drafted and is open to the public currently. So we're going to go through similar tables or matrices just like Michaela. So for parking, minimum parking requirements, the requirement from the state is you may not require more than one off-street parking space per dwelling unit for a residential development within a designated growth area. So that would mean that you would need to update your existing parking requirements in your land use or zoning ordinances, subdivision ordinance, or wherever your parking requirements live in your regulations. For the offsite parking agreement piece, this requires a developer to satisfy or allow a developer to satisfy parking requirements through offsite parking agreements with existing parking facilities located within a quarter mile of a development site for both in and outside of a growth area. This would require the developer or applicant to essentially provide evidence that the offsite parking space would provide for the required parking spaces for the residential development, either through a parking study or part of the traffic study. So it's just another way to provide parking not on site, but close by to the residential development to make it a little easier to develop those properties. And again, this would be in addition to your existing parking requirements wherever they live in your ordinances. We'll move on to LD1184, which is an act to require municipal reporting on residential building permits, dwelling units permitted and demolished, and certificates of occupancies issued. This was signed into state law in July of this year, and municipalities must comply by January 31 of 2026, so in a few months, and annually thereafter. The law requires annual housing data reporting by municipalities with over 4,000 residents, and it will require coordination with the Maine Office of Community Affairs, or MOCA, and your regional planning organization, such as us, SMPDC, and there's no rulemaking for this LD. So the reporting bill here has a few requirements, which we'll go through. The first one being related to municipal residential building permit applications. So the requirement is to report of residential building permit applications, including number of applications submitted, approved, denied, and categorized into single family with ADU, 2 to 4 family, and 4+ family residences. The second is municipal residential units. So report the number of dwelling units permitted and demolished within that year. And then finally, municipal certificates of occupancy, or C of O, which you'll need to report the number of certificates of occupancy issued and number of those which are affordable to 81 to 120% AMI and below 80% area median income. So essentially, this is the municipal staff or town staff needs to ensure collected building permit data includes this information in the central column there. And then the staff will prepare an annual report and coordinate with your regional planning organization to submit to the state. And finally, the state is prepared to fund 90% of the municipal expenses incurred through this required reporting. And the last bill of the presentation is related to chickens, believe it or not. And it's an act to allow the keeping of chickens on private residential properties. It was signed into law in late May of 2025, and municipalities needed to comply a month or so ago, again, September 24th, 2025. This law also preempts local zoning control over regulating of chickens on private residential property, and there is no rulemaking. So obviously, this is about the keeping of chickens, and it essentially prohibits municipalities from prohibiting people from keeping chickens on their residential property. So the steps to adopt this would be to amend your zoning ordinance to allow chickens on residential properties in your town or community. However, municipalities can adopt reasonable regulations and or guidelines, such as setbacks, enclosures, or anything else that would be considered reasonable to allow for chickens on a residential property. And I think at this point we have gone through the bills that we'd like to share and discuss, and Reagan will take us through the rulemaking and state resources. Thanks.
Great. Thank you, Jamel. Michaela mentioned for a few of the bills that rulemaking is currently drafted and open for public comment. So as she said, that includes 1829, 997, and 427. And those are all open and available online. The deadline is October 31st, which is this Friday. I believe it's been open for about 3 weeks. You can find the proposed rule on our website, smpdc.org/ledge, short for legislation. It's also on the state website, and they're accepting comments directly to Hillary Gove, who is at DECD. So you can just email any comments you have directly to her. And I also wanted to mention, in addition to it being written in the law that 90% of the cost for the reporting will be funded by the state, there has been discussion at the state's listening sessions about there being potentially funding for reimbursement, specifically of 1829 and some of those other laws that require a lot of implementation. Nothing is settled at this time, but just so you're aware, there could be information coming out sort of at the turn of the year about whether or not they will have funding available for that. And then we wanted to talk through a few of SMPDC's resources. So we have created a set of 3 2-page fact sheets that include all the information you've seen in this presentation for 3 of the major laws. And we're kind of hoping that these, in addition to kind of listing these requirements, they also include some questions for you to ask to make sure that you're addressing everything, and a checklist for implementation. So something to help you walk through the adoption process. And they may also be helpful resources for you to print and share with your planning boards or other municipal staff if you are in the position of having to educate other people about these changes. We also have a webpage, which I mentioned earlier, smpdc.org/ledge. We have a list on that page of other legislation that we haven't covered here that may also impact municipal zoning and planning. Some of those were enacted in this last session, and some of them are carried over for the next session. So if you're interested in following that sort of thing along, we're going to have that sort of as an ongoing resource on our webpage. And also anything, this webinar recording, the slides from this, and our fact sheets are all also going to be available there. And then lastly, SMPDC and our planners are available to support our member communities with ordinance amendments or adoption. So if you are interested in learning more about that sort of direct technical assistance, feel free to reach out to us. We've also included all of our contact information on the slides, which will be sent out after the fact. So we're on to the point in the presentation where we are open for questions. And as we had hoped, we got through sort of the slides of this pretty quickly. So we do have plenty of time to be here and answer some questions. I'm going to keep the slides up because we have gone through 5 different laws. I think it will be helpful for us to go back and reference based on specific questions. So just keep that in mind. That's there. You can ask questions through the Q&A, which is on the bottom of your page there. You should be able to highlight that and see it. And you can also raise your hand, which I see we have a couple of people who've already done so. So if you want to speak up, you can raise your hand and I'll call on you there, or you can put some questions in the Q&A and we'll kind of go with the flow. So I'm going to start with people who are raising their hands. Eric Cousins, you can unmute.
Hey, Regan, I'm not sure if this is for you or Michaela. I was curious when they were working through the 1829 legislation, I think it was 1829, there was some debate about whether or not commercial development districts included industrial zones. Has that been figured out? Do we have to allow residential and industrial zones? Is the question.
So the other thing I'm kind of meant to say as I was queuing this up is I think we're gonna direct a lot of these questions to Phil Saucier because that's why we have him here. So I don't know, Michaela, if I can't answer that one. I don't know if you can, but Phil, give us your best shot.
Hi, this is Phil Saucier. Yeah, so the law only applies to commercial uses, commercial districts. What I was trying to do, and I had it on my screen, I just lost it, was there is some rulemaking going on right now to see if that's changed. And I'm sorry if someone could, Michaela or someone has it in front of them, you could see if there's a definition, but as the statute alone is only in commercial districts and how that would be defined by the municipality.
There is a draft definition of rulemaking for commercial use. It says commercial use means the use of lands, buildings, or structures, the intent or result of which is the production of income from the buying or selling of goods or services. Commercial use does not include a home-based business, the rental of a single dwelling unit on a single lot, or incidental sales of goods or services as may be allowed by permit or standard. It doesn't clarify that it doesn't mean industrial, but it does say selling of goods and services rather than making of goods. So I think that's one distinction there.
Yeah, no, I agree.
Great, thank you guys. Jason Garnham, you're up next.
Yeah, thanks everybody. Jason Garnham, Town of Kittery. I just wanted to make sure I'm clear on the amendment that's part of LD 1829 to subsection 4364A, the one that allows 3 units or 4 on any residential zone property. Does that, I think I know the answer, but I want to hear it out loud. Does that also apply to properties zoned residential that are neither served by utilities nor located within a targeted growth area? So, an existing 40,000 square foot lot in a zone that currently has a 40,000 square foot per unit density. Would this section of the new law override that and require municipalities to allow 3 units on all such lots? Thanks for my question. Let me know if that doesn't make sense.
No, I think I understand what you're saying. So in other words, so areas that either, and there's a similar question in the chat. I think what you're saying is for areas that are both outside the growth area and are not served by public water and sewer, then the statute is silent on any kind of restrictions. And so I think that my position, I think the intent was to allow municipalities to enact dimensional standards, including, units per sort of minimum lot per dwelling unit requirements, similar to what was under LD 2003. The only requirements are if you're in a designated growth area with or without water and sewer, essentially, or outside a growth area but are served by water and sewer.
Got it. Thank you, Phil. So that very first part of 4364A is intended to apply to growth areas and utility serviced areas, in your opinion?
Well, so not necessarily. So they have to be read in conjunction with each other. So you may remember out of LD 2003 also had sort of a minimum of 2, 3, or 4 units per lot that are required, but then municipalities could still adopt minimum dwelling units per minimum sort of density requirements. And so some municipalities did, right? So you could say 5,000 per dwelling unit, 10,000 per dwelling unit. What this new law says is you can't establish those density requirements that are different from those 3 areas we just went over. So you still could, municipalities still could have density requirements that in essence would keep things in a larger sort of lot if it chooses. It's just silent on that.
I think I understand. So like
Okay.
a 40,000 square foot per unit regulation would still be legal, and the municipality would only have to allow 3 units on a lot that's large enough to meet that standard.
To meet the standards, that's right.
Okay,
And that's the way
Very
that LD
helpful.
2003 works today, but this amends that requirement.
Yep. Okay, that's very helpful to me. Thank you.
Thanks, Jason. Okay. So I want to address a few of the questions in the Q&A. I love to see that people have already ran over to our website to try and access the fact sheets. You are right that there is an error when you're trying to click on them. That I was trying to figure that out right before this meeting, but we will be sending them out to everybody who is on this call and anybody who registered. So you will get those very shortly, and we'll make sure to fix that link. So thank you guys for bringing that to our attention. I'm going to go to a couple more in the Q&A list just to make sure we're kind of balancing things. Maxim asks, do ADUs count when counting units for sprinkler requirements? Example, if it's a duplex with one ADU, would that need to be sprinklered, or would that be considered 2 units plus an ADU?
So the short answer, yes, it does count. And that's the very first provision in LD 1829. So I'll just read it to you. That, fire suppression sprinklers are not required for ADUs unless the ADU is within or attached to a structure of more than 2 dwelling units, including accessory dwelling units. So you include the accessory dwelling units when arriving at the 2 or less that can be exempted. I think that's a pretty straightforward answer on that one.
Okay, thank you. I know you said one of these is similar to the one that you just answered, so if I read that one, you just let me know. But next up is Dan, clarifying question on the density examples. A municipality can no longer mandate fewer units per area than what is shown in the examples, but a builder is still free to build fewer units on a lot than the minimum standard, ?
Right. These set minimum standards, but you can always you can use your lot the way you want it, as long as these are requirements for municipalities and the regulations.
Right. Not to an individual private owner. Right. Okay. And folks, feel free to raise your hand if we don't fully answer your question and pipe up. I'm going to go, speaking of that, to somebody raising their hand now. Let's see. Tracy, you can unmute.
Hi there, it's not Tracy, it's Ben Harris from Dayton, but I'm with Tracy.
Hi, Ben.
And,
Hi, Ben and Tracy.
We were having a conversation last night in the town office around the training requirement. We had a little bit of confusion because the training specifically mentions in subsection 4 about land use. And typically the MMA training that we attend is more about rules and procedures of boards and committees. So it didn't seem like it fit the definition, but it seems like it's being sold as meeting the requirement. And then the other part of that is it within everybody's reappointment, or is it once? And then once they're good, somebody serves 3 5-year terms on the planning board, do they only need the training with their first appointment or with each additional appointment? Thank you.
Thank you. Yeah, so the training requirement does include reference to land use planning. So I would, the kind of training I do, and I know SMPDC does, and some other, when we were asked, and I know MMA does too, is you would include some responsibilities of a planning board, for example, some basic sort of what site plan review is. I think you would go through some of the roles and responsibilities of a planning board member, which include the land use components of it. It doesn't provide any other guidance, right, in terms of how much specificity we'll have to get into. But we've been doing our trainings for years. I don't think I'm going to need to change too much of it to the extent I'm asked to do the trainings. I know MMA has a training on, but we've always included some land use components as a result. In terms of your question about frequency of training, it does only require training one time, my reading of this. So it's within 180 days of appointment. And then also in the very back of LD 1829, this is this is what we call implementation language, or the non-allocated language. There's a provision in section 22 of the law that applies this to sitting members too. And that's when 180 days of the effective date of the law. So 180 days of September 24th, 2025 for existing members.
And just finally, if I read it correctly, the municipality can create a training standard to meet the letter of the law, as well as a group such as Southern Maine Planning or MMA.
So that's a good question. Actually, a number of people have not to make it too complicated, but a number of people I work with and municipal attorneys and planners actually have been sort of puzzling over this language. So one way to read this, and I know that there, by the way, I was just going to mention this as an aside. I'm aware of at least one, if not a few other legislators who are going to be proposing fix bills, quote unquote, or amendments to clarify. So we may see some language that we just went over be further amended in the short session. I don't know if this is one of them or not, but one way to read this is that the training is required by a state agency, that's pretty clear, or a statewide association representing municipalities, MMA, likely is what that means, or a regional council or municipality within 180 days. So you're getting at the or municipality. It's written in a somewhat strange way, and it was some people have interpreted that meant regional associations of municipalities like SMPDC. I know some people have said no, municipalities. So you could have your town attorney do it, or your planner for that matter.
There is no Oxford comma there.
There is no Oxford comma, and I'm a big fan of Oxford commas.
So it kind of does lead to your
right.
member.
It at least has some. It at least leaves it a little bit open about whether the municipality. It doesn't. What I don't. I think the reason why yet it doesn't include an Oxford comma, and there's no reason to include it. If it could have just, they could have just said there. We need to have some trainings. Period. Right, but they made a point of listing out these different entities for whatever reason. So I guess more to come. That's one of those answers. I don't have a clear answer right now on that. But
I don't remember if this is addressed in
training can work, and a regional association training can work. Yeah.
And really for us, it really came down to if we could buy the MMA training for 30 or 60 days and then have people come in and view it themselves and sign off on it, or does it need the certification of some sort?
It's clear. What I would say is, I'm sorry to interrupt if someone's just talking. What I would say is I think I would have like a local system where at least you have some sort of, you've noted it in the file, the planning file. And by the way, it's not only planning, it's zoning board too. Right?
Yeah.
In the file somewhere similar to the requirement for FOA training, which it does apply to planning boards. And I know not every municipality does it, but there is actually a certificate you can download off the FOA Ombudsman's website. You can make your own too. There's nothing that says you have to use, but it's just something nice to be able to say this person completed it. It's in the file. There's a check mark if anyone ever asks. There's nothing in the statute that has any kind of remedy if someone doesn't, but someone could always raise that, I suppose, and someone's opposed to something or something like that. I would just make sure you have some sort of a way to note who has had the training and who hasn't had the training.
Perfect. Thank you.
Yep.
Good question. All right, back to our written FAQs. So we've got a question here from Kittery. It says, Kittery allows one ADU per every owner-occupied home on a property. As an example, a duplex on one parcel would be allowed to build a total of 2 ADUs. But it doesn't allow ADUs for rented properties. For example, a 6-unit apartment cannot add an ADU to their building. Are you now saying that every residential building can have an ADU no matter the type? Is it 1 ADU per principal residential dwelling or 1 ADU per lot?
So this is actually this is a somewhat substantial change from LD 2003. What the new law allows is an ADU must be allowed to be added to both a single family or a multifamily structure is all it says. So and then you cannot prohibit ADUs from being added to only owner occupied. That's a somewhat significant change. I am aware that there are some communities that have requirements for owner occupied units, and that will no longer be allowed once this is in effect in your community. And so that's right in the 1829. So the language I'm citing to is section 17 of the law. Municipalities shall allow the construction or occupancy of an accessory dwelling unit on a lot, even if the owner of the lot where the accessory dwelling unit is located does not reside in a dwelling unit on that lot. So it can no longer be owner occupied only.
That's great. I think that addresses the first part of that question. I may have missed it, but did you address the question about, is it 1 ADU per principal residential building or 1 ADU per lot?
It's per on a lot, but I guess it doesn't, the board principle really doesn't matter, I guess, is
Right.
that's what's being thrown off by that. So it's allowed on a lot, either you know, on a single family or a multifamily lot.
Here, Maxim is raising his hand now. I think he's going to add some context. Go ahead, Max. I think you can unmute.
Thanks, Reagan. Bill, I'm sorry if I phrased that confusingly. I guess just for context, the way Kittery treated ADUs was we see a lot of subdivisions by unit in Maine, and we thought that the intent was to allow single family dwellings to each have their own ADU. So we treat it to basically the reason we tie it to owner occupancy is to allow more ADUs on a property that has a number of single family dwellings. And by tying it to owner occupancy, it also allows multifamily dwellings that are owner occupied, like a row of condos or townhouses, to also theoretically have their own ADUs. So the reason I was asking was just to clarify. And the trade off to that was that by allowing any owner occupied building, whether it's single family, duplex, or multifamily dwelling, to be allowed to build ADUs, the trade off was that an apartment that is rented does not have that allowance, just to make things less confusing and avoid the perception of letting somebody build an apartment and then add a unit or two additionally. So what I'm hearing is that, if I'm hearing correctly, is that now any residential property in a zone is allowed to have an ADU, whether it's a single family dwelling, a multifamily dwelling, condominium, or a multifamily dwelling apartment where all the units are rented. Is that
That's right.
correct?
Yeah, it doesn't matter whether it's rented or not. That's the biggest distinction. It's what owner occupied. It doesn't matter if it's owner occupied anymore.
Okay. And then whether or not a town ties the amount of ADUs to how many buildings are on a lot, the state is only requiring it to be tied to the lot itself.
That's right. You're right. You must require at least one.
Okay. Thank you so much.
Great.
Another part to that still is that you can't require the owner occupancy anymore.
Right. Yeah.
Yeah. So we have another attendee here drawing attention to an interesting distinction in the residential to commercial law. They ask, does the state requirement say that residential must be allowed in commercial structures or just residential in commercial zones?
Yeah, that's a good clarifying question. So it's an either really. So and that slide kind of mentions both. So what that law requires is residential units must be allowed in areas zoned for commercial use, and that includes, but it's not limited to, buildings that are either vacant or partially vacant retail properties. In other words, partially vacant retail, so those buildings themselves as well, as it relates to retail specifically. Interestingly enough, covered. I think that means like vacant malls or semi-vacant malls or those kinds of things. But yeah, so it's really both. It's really both.
Okay.
Bill, will you add to that actually? Because it's titled, or the first provision in it is titled residential units in areas zoned for commercial use. But then the lines under that provision immediately say a municipality shall allow residential units within buildings located in an area zoned for commercial use. So the within buildings part is right there. So I'm just curious if this means a municipality has to allow like freestanding residential units in a commercial zone. So the building has no commercial use whatsoever, and it's only a residential use.
It's just vacant. I mean, that's a good question that maybe needs to be sussed out through rulemaking. But as I read it, as like a standalone building, I guess what you're getting at is it doesn't really address new buildings. Like could someone come in and build a new residential purpose only building? So that's not exactly addressed. It's just within buildings located in an area zoned for commercial use. I mean, I think you could read that either way. I think reading it the broader way, you could say that yes, you would have to require buildings to be built. I mean, you could allow buildings to be built for commercial residential purposes, unless the rule making is going to clarify that in some way. I would take the slightly more expansive view at this point. I should
Yep.
preface this by saying, obviously, there's a lot of different communities on here, and you should consult your own town attorney as it relates to your specific ordinances as you move forward.
Yes, we should say it once and maybe say it again.
Yeah.
This is a good question that I'm sure applies to lots of folks on the call. What if we do not have public water or sewer or designated growth areas?
Yeah, I think that was what we answered. So that was the one that was
Okay.
sent question up early on, which is it's not addressed, and so I think municipalities can continue to regulate those areas with minimum dwelling area per dwelling requirements.
Got it. Beautiful. Thank you. On to the chicken law for a minute, anyway. The chicken law states that we cannot prevent the keeping of chickens in residential areas. Does that include shoreland residential areas? And additionally, do people need to permit their chickens?
So yeah, I've got the law here. I just want to make sure I've got it right in front of me. I mean, it doesn't. It's not addressed. It's a very basic law if you haven't read it yet. And it just essentially says municipalities cannot adopt regulation or ordinance that prohibit a person from keeping chickens on that person's residential property. Defines what a chicken is. But then it goes on to say, and this is kind of, I guess, sort of gets to your question, which is, however, the section may not be construed to limit the home rule authority of a municipality. So on one hand, it is limiting the home rule authority, but I think what that language means is that municipalities can still adopt reasonable regulations, whatever that ends up being for your community. So you can't prohibit them, but maybe you could have, again, some of this will be sussed out over time, maybe even with litigation, because you have to read this in conjunction with the recent amendments to our Constitution on the right to food act and those kind of things like that. But some reasonable regulations that municipalities have, for example, maybe sometimes there's setbacks, maybe for the structures, the coops, things like that. But no, it doesn't address shoreline at all. I will say, if I don't know if DEP will take a look at Chapter 1000. I mean, so Chapter 1000 is an express preemption of municipal home rule authority, and obviously, as everyone on this Zoom knows, that you have to implement shoreline zoning. But this is just silent on that issue at this point.
Yep. Okay. Thank you. Okay. Back to 1829. How do we rectify rulemaking for LD 1829 that says implementation is voluntary for towns and funding has not been provided by the legislature for implementation?
So I'm not sure I know the answer to that question. I don't know that it's voluntary.
I don't remember seeing that, language.
But maybe I missed, because I'd want to review these rules one more again. It could be, well, I don't even want to surmise because I don't know what it says right now.
Galen, if you do want to pop on and raise your hand and point us to that language, feel free. But I think I agree at the moment, I'm not familiar with that. So this is maybe asking that same question again, but just probably helpful to restate it. Our town does not have town water or sewer, a comprehensive plan, or growth areas. How do these laws affect our town in regard with the requirement to allow 3 or more dwelling units on one lot? That's going to be.
Yeah, I mean, I think we should address that, right? Which is those municipalities that don't have growth areas or water or sewer can continue to regulate in the way that they'd like. There's some communities that don't zoning at all, so really that doesn't affect. I mean, people can already build as many, if you have, I mean, I represent some towns that have no zoning at all, right? So you could already do as many as you can fit on there. So it's really these requirements apply only as it's specifically delineated in 1829.
Great, thank you. I think it's helpful to restate it differently.
There are some other provisions of 1829, I guess, as a general provision that would apply, right? So maybe like the training requirements, for example. I mean, that's a general requirement in that law, and things like that. I know we're getting close to running out of time, so actually we had talked about, while we're on 1829, I do want to just bring up one provision that we didn't have in our slide, so everyone's aware of it. and that's the rate of growth provision. So there, LD 1829 also contains a provision that prohibits municipalities from enacting rate of growth ordinances that limit residential development in designated growth areas. So a easier way of saying that, growth caps, right? So if you have a growth cap ordinance, and you can no longer have those kind of growth caps in your designated growth areas. So I just wanted to point that out before this was over.
That's good, Phil. Thank you. I believe our invite had us going until 3:30. So if you've got the time, I think we can keep trucking. Which we do still have 15 open questions. So I'm going to keep working through that. This one says, does LD 1829 take into account LD 2003? For instance, if an apartment building's first 4 units is 1,250 square feet and the remaining 5,000 square feet per lot. Sorry, guys. So an apartment building's first 4 units are required to have 1,250 square feet and the remaining 5,000 square feet per lot. Is that then the base density is that 2.5 times for affordable housing?
Yeah, I think I know. I can understand what James is saying. So, it does take into account LD 2003. In fact, what it did is it amended the laws that were enacted in 2003. So it builds upon LD 2003. Many of these provisions we talked about are actually amendments to those sort of 4 core statutes that were adopted as part of LD 2003 and changes them in certain ways. So I think the part of your question is essentially what base do you use for the affordable housing? Well, the base is the underlying zoning, right, for that district, and then affordable housing qualifies could have 2.5 times that base. So if the base is what you just described, yes, it would be 2.5 times that. I think that answers the question.
Okay, great. Just trying to follow.
And again, it is limited, right? So the affordable housing, it's in the growth areas that's served by water, so it's not everywhere in your community.
Right. Okay, so this one asks, how does 1829 apply to a subdivision covenant deed restriction that does not allow ADUs?
It does not change the provision that subdivision covenants can still prohibit. Those are private restrictions on land. And so there can still be private restrictions on land. It also doesn't change. So when I say the sort of 4 core, really 3 core statutes that are part of this is what used to be called the up to 4 units law, the accessory dwelling units law, and the affordable housing density law, and all and those second 2 all had provisions that were not removed that says restrictive covenants would still apply. This doesn't override any private contractual matter, like in a homeowner's document or a covenant in your deed, for example.
Okay, that's great. This question goes back to one of the questions about LD 2003. I remember people really being a bit confused about when it was first adopted. So this asks, could you clarify if an applicant proposes to build a comparable public sewer or public water system to service a lot in a non-growth area, would we be required to lower the minimum lot size to 5,000 square feet?
It's a good question.
Yeah.
Yeah. I don't, so that provision simply says if a lot's outside a designated growth area and in an area served by a public special district or other centrally managed water system, the answer is yes, the minimum lot size cannot exceed 5,000 square feet. I think, again, this is something you're going to want to talk with your town attorney about, but I would think that if someone comes in with a proposal to have a central system, and I know that, by the way, there's some concern around that because it's not just public systems. There's ways to,
right,
as sort of this comparable system is defined. It could be something a little different, or maybe that what you're not thinking about, that they could maybe use the minimum lot size. The reason why I'm pausing because I actually don't know if that's something that's being addressed right now through rulemaking in the comment period, but it's a good question to keep an eye on.
Okay. Yeah, I feel like in the LD 2003 law, it was almost a little bit more specific that there could be a private comparable system, whereas this one doesn't have that word private in there. but you're right, rulemaking should be the place to look for
Sort
that.
of other comparable system is what it uses, centrally
Yeah.
managed. Yep.
Okay. Thank you for that question. So we have one that says, assume a town with a town meeting form of government declines to update its ordinances for any piece of this legislation. What is their legal risk or liability? If a resident, applicant, or developer proposes an ADU, tiny home, new subdivision with 4 dwelling units per lot, etc., and the planning board and CEO decline the permit or the subdivision application, what is the town's risk if sued? Other than having to allow the applicant's request, can the town be held liable for damages?
Good question. And I see there's another question that's related, the first one at the top, assuming the town meeting form of government declines to update. And Brooks Moore's question, I think, is similar to the next one.
Okay.
So the answer is, in my view, these requirements will apply. They're express preemptions of municipal home rule. We got this question a lot under LD 2003. What could happen, obviously, is litigation. So, for example, if your ordinances were not amended and a developer wants to come in and take advantage of these provisions, your planning board applies your existing ordinances because that's what you have on the books. That person could appeal, and they would almost certainly, in my view, likely win if their argument was that they're just complying with these new provisions we're going over to LD 1829. These are required provisions. So I understand that there's political processes and town councils and public and town meetings have to make their own determinations, but that's what could happen if they're not adopted. Is that these would still apply. They would likely have to go through the court process to actually have it in place because you'd have two conflicting documents for that planning board to apply. But ultimately, I think a court would determine that these do apply. So expense, in terms of liability, I know people don't like when lawyers use likely or probably. I would say likely not, but almost certainly, I would say in this case, in the sense that we have the Maine Tort Claims Act, which does protect municipalities and provide immunity for certain legislative determinations, for example, and determinations by enforcement decisions and things like that. Your planning boards, your code enforcement officers, your decisions to enact or not enact ordinances. So there would be a very strong defense against any kind of liability, but there would be risk in terms of the cost. It's not cheap to defend ADVs, especially they can go all the way to the law court, as some of you know, and it can be years. So there could be still very much a lot of expense associated with it.
Bill, could the municipality also end up having to pay for the applicant's legal fees as well as their own?
It depends on if there are certain counts they bring. So the answer is no. Maine is not an attorney fee state generally, unless we have something that says otherwise. So what I mean by that is appeals. Each side is responsible for their own attorney's fees, and I know a lot of municipalities know that. It's frustrating, sometimes, but you may go through the whole thing and you have your fees. 80K, so an enforcement decision. That's an example where the legislature has said, if you bring an enforcement matter and the municipality is successful, we can recover our attorney's fees. So if it's just an appeal, for example, of a denial of a project, I would say no. If whatever, if they bring some other claim that I'm not aware of, constitutional claim, something like that, then there's sometimes opportunities to ask for attorney's fees. So, but on a standard appeal, my answer would be no.
Okay. This question asks about the intersection between a couple of the different provisions. So if 4 units per lot is allowed in a growth area or so in an area with a growth area or served by public water and sewer, I can then add an ADU attached or detached, which is not subject to density, for a total of 5 units. Is that correct?
Right. Yeah.
Stacking. That's you saying yes, that's
yes,
correct.
I'm sorry. Yeah.
Okay. Yep. You're
And in fact,
understanding.
I was pausing because I always like to find the language, right?
Yeah.
So the language in that statute this actually is just a tweak to the existing language. Municipality shall exempt 1 accessory dwelling unit on a lot from any density requirements or calculations to the area in which the accessory dwelling unit is constructed.
There you go. Okay. Thank you. Thank you, Dave, for that question. This one's a little less technical, which is nice, maybe for Michaela or Jamel. This is a question for our SMPDC people. How are smaller towns working to implement these new laws into their zoning ordinances? Do they have committees reworking the zoning ordinance, the planning board, or are they simply hiring it to be done? Would like to take that.
I guess I can take this. Ultimately, I would say it's up to the community or town. If they feel comfortable working with your regulatory or zoning language, then obviously you're free to change or amend as needed. As Phil and Reagan have said, we would suggest working with your town attorney to make sure that the language is compliant and solid. But again, if your committee or your planning board does not feel comfortable, we're happy to chat with you if you're in our region and are a member to work in the changes to your ordinance. So up to you. We're happy to help. How's that sound?
Yeah, and I think, they've asked sort of what is already happening. I would say we haven't heard of a lot of towns really actively diving into this just yet. I think people are still wrapping their heads around it. And with LD 2003, we saw a mix. It's just depends on what people are comfortable doing. This next question asks, does a 4-unit building with an ADU trigger subdivision? Sort of maybe a slightly different angle at that, similar to that last question.
Good question. I believe it would. So I'm looking at the subdivision language as 5 units, and just 5 or more dwelling units. And it's the subdivision statute. We're outside of LD 2003 now, in a 5-year period. So it appears to me that it would be at this point.
That's a tricky one.
That is a tricky one.
Yeah.
Because the other provision that allow, yeah, we might have to sort of follow back with a couple other follow-ups. I also do want to circle back for a second because there is a nuance
Please.
as it relates to that, the answer I just gave you on the ADU, the stacking. There's some new language that was added, so that's a little different than what was in LD 2003. So I do want to circle back for a second, if you don't mind.
Please.
So under the density law, if you look under the provisions, sort of A, B, and C, the sort of 3 categories we've gone over already, sort of in the growth area, outside the growth area, in the growth area with water sewer. There's a provision that says if 4 or fewer units have been constructed on a lot as a result of the allowances under this section or under 4364B, which is the ADU statute, the lot is not eligible for any additional increases in density, including under that section, unless more units are allowed by the municipality. So again, this is one of those provisions that I know that may be being cleaned up as a fixed bill because it's not clear, again, if you're reading that out loud and you do not, it's not clear exactly what that means, to be honest with you. 4 or fewer, which seems a little strange, right? Instead of 4 or more. But then also as a result of the allowances under that section, which allows 4 or 4364B, which allows an ADU, then you can't have any additional. So I just want to point that out. I'm not sure it sort of changes my answer, but I think that there's some nuance there that maybe needs to be sussed out through a future amendment and or rulemaking.
Okay, that's helpful. Thank you. If that added some confusion to your question and you're still on the line and you want to pipe up to ask more, please feel free to do so.
Yeah.
Okay. This is a question about the reporting requirement. So for LD 1184, reported ADUs are only referenced in coordination with single-family dwellings. Given the change to the definition of ADU to include multi-unit structures in LD 1829, is it anticipated that all ADUs permitted will need to be reported? I think I'll pop down to that one here.
Yeah.
Right, because yeah, the only place it's mentioned in this is in terms of the single family with ADU category under applications submitted, approved, denied.
Yeah, it's an interesting question. I assume this was something that was missed. I mean, these are bills that were passed separately.
Mm-hmm.
And so 1829 expanded that view. I mean, I wonder if, it's a very good question. As you read it today, it's categorized single family with ADU, 2 to 4 family, and more than 4 family. There could be some rulemaking there. I think there's a little flexibility there for the department to say 2 to 4 family or more than 4 family could potentially include ADUs. It seemed to me that
Mm-hmm.
the department would want to know the ADU count, though. I mean, so I could see this being amended in the future, just as context. Uh, this, from my understanding, is really to give the department some data that was part of 2003. So one of the responsibilities under LD 2003, you may remember, was to establish statewide housing production goals. I used to give this presentation in LD 2003. That was one of the slides I would have. And the department, one of the things it says is consider information it needs, consider information submitted to the department from municipalities about current or prospective housing developments and permits issued for the construction of housing. So that was already in there. This is, I think, what I saw this as. This was a way to start getting that information in a more sort of systematic nature. So I could see that being amended in the future, clarified through rulemaking to say just any ADU that's permitted, but it's not the way it reads today.
Okay.
Seems like it wouldn't hurt to report it.
Right. Yeah.
Or at least start tracking, right? Like if
Yeah.
this is sort of going to have to maybe force some towns to create that tracking mechanism, and maybe
Right.
it's worth it to add a couple of other things to that list while you're already doing it, right?
Yeah.
Yeah, because I think you make a good point that it could be asked for eventually, and it would be nice to already have it in your process, right? Great, thank you, Zach. This question is specific to slide 12, so I'm going to pop up there. On slide 12, please define a development. I think that's why we have development underlined here, and that may go back to that question that we've already addressed about, does this refer to a structure versus a lot kind of a thing?
Right. And I don't see a definition. I'm looking, I'm sorry, I didn't have it up on my screen earlier, the proposed rule. I don't see a definition for that either. They do have a definition for, like you said, commercial use, but I don't see commercial development.
Right. I think I don't, never want to assume, but oops,
Yeah.
I've gone the wrong way. It sounds like they're kind of using those interchangeably a little bit.
Yeah.
Okay. We're getting down there, folks. We've got 4 left in about 15 minutes. So this question's about the Saco River Corridor Commission, whether or not they would also need to change their regulations to meet these new standards.
Good question. That's not a question I've had before. Saucier River, which is its own unique animal. I would look at off the top of my head, I do not believe LD 1829 affected Saucier River Corridor Commission, but you'll want to take a look at that with your attorney to make sure. These apply to municipalities generally, but you're going to want to make sure the municipalities are sort of defined in a way that may include other. But this, I'm not aware of anything on that.
Got it. Thank you. Okay, this question about flooding. If a growth area with water and sewer is in areas at risk of flooding based on various models, like the 20-year, 50-year, or 100-year flood, would it be a mistake to encourage denser housing? Can there be exceptions for some areas such as this?
Yeah, that's a good question. There is actually a provision in one of the provisions we just talked about that does actually include a exception for flood purposes. I apologize, I wasn't prepared for that question, but I do know that it was addressed in one of the statutes. Maybe you can go back to that and I'll see if I can answer that before the end of the time we have.
Okay, yeah. I think one thing to keep in mind is that I believe, your regular floodplain would include the 100-year which should be included in your resource protection zone. So that probably is going to play into this. But I'll keep that one as unanswered for a little bit. This one asks, I think it's referring to something we've already said. To confirm, both LD 2003 and LD 1829 requirements are only required to be adopted by a town if they meet the town water, sewer, and growth area criteria. I think there maybe are certain provisions that only apply to
Yeah, I
towns
think
with
that's a little
those
bit
things,
too-
but then there are others, right?
Yeah, that's a little too broad of a statement. There are provisions in LD 2003 and 1829 that would apply, that do apply everywhere. I think what the person is asking is as it relates to specific areas that are called out, for example, growth areas, areas that are and areas that are served by water or sewer, those provisions obviously apply specifically to those provisions only. But there are all kinds of other provisions, as we've gone over in both of those bills or laws that will apply.
Yeah, that's a good way to put it. Thank you.
Like the ADU provisions or the I think with this next or with the later question about planning board review threshold, those apply everywhere.
Correct.
Right.
Okay, yeah, the next question, nice transition. Would the change to the planning board review threshold only apply to places with public sewer and within a growth area, or would this apply to all towns? It's the way the question's worded, but
So the planning board review applies everywhere. It's a provision that it's a standalone provision in that just says municipality may not require planning board approval for 4 or fewer dwelling units within a structure. What that really is, I think, was the attempt of the legislature to tie into the new definition of a subdivision, which now is 5 or more dwelling units.
right. So it doesn't specify where, specific areas within a town. It's all.
That's right.
All applications. Got it.
Bill, I have a hypothetical question based on that. Say, you have a 4-unit structure, and then 5 years later, you build a different 4-unit structure. That would be exempted from planning board review and from subdivision review because it's outside the 5 years and is under the unit count.
Yeah, if it wouldn't meet the definition of a subdivision, meaning, division of a lot, 3 more units in a 5-year period or 5, dwelling units in a 5-year period, that wouldn't be required. That's right.
Interesting.
Okay.
I think I can answer that first question too, as you, which is, I think it's really the first question is really a policy question. I think it's not, is it a mistake?
You're talking about the, would it be a mistake to allow and increase density in flooding areas?
Yeah. So I mean, that's a policy question for the policymakers, but there are some exceptions. So I'm not aware of exceptions. I did find what I was thinking about. It wasn't in the sort of density provision. It was actually, interestingly enough, in the commercial use, residential uses in the commercial use law, interestingly enough. So we didn't address that on that slide, but I want to point that out because it sort of somewhat gets to that question. So municipalities shall allow residential units and buildings located in areas zoned for commercial use, except when a municipality determines that flooding or other natural hazards in the zone make a building located in areas zoned for commercial use unfit for residential use. So that's an interesting sort of floodplain issue. But that's very specific as it relates to the residential units in commercial zoned areas.
Yeah, that is interesting.
So the municipality can make that determination, is all it says, and I assume that would be through its ordinance process.
Mm-hmm. And then what I said earlier about, floodplains being included in resource protection, shoreline zoning applies to all of this.
And that's the
right?
other part of it, right? To the extent that the floodplain is within the shoreline zone, shoreline zoning would apply regardless. Yeah, and these 1829 did not remove that, just like it didn't remove the provision that said private covenants still would apply.
Right.
The shoreline zoning rules still apply. Yeah.
It's good clarification.
Yeah.
Okay. We have our last Q&A, so we still have 5 minutes if anybody wants to pop in. But She's referencing the law. It's great. Looking at section 4363A sub 1, it reads that a municipality shall allow at a minimum 3 dwelling units. If we increased our allowed of ADUs from 1 per lot to 2, would we be complying? I think that's assuming you don't change the dwelling unit allowance, but you just change your ADU allowance from 1 to 2. Would you be compliant?
Yeah, I mean, so that provision, I think she means 4364A, not 63A, but it's a 3 or more. So municipalities must allow at a minimum 3 dwelling units attached or detached, including accessory dwelling units per lot. So I think it does include accessory dwelling units.
Okay, so yes, they would be compliant. Okay. All right.
All right.
I think that's everything. Last chance for anyone who'd like to pop in. I'll reiterate that this has been recorded and we'll be posting it on our website. The slides will all be available on our website, and we will fix the links to the fact sheets, which we're very anxious for you to see. So we'll also send them out right away after this. So all of that will be available to you. And if you have any other questions or want to reach out to talk more, feel free to reach out to us. Thank you so much for being here, Phil. You're a rock star answering all those
Thanks
questions.
for inviting me.
Thanks so much, Phil.
Okay, thank you guys.
Thank you.
Yep.
Have a
Appreciate
good
it.
rest of your afternoon, everyone.